for violating the civil rights of the residents of Fort Lee.
We'd like to return to more press conferences following the guilty verdicts at the Bridgate trial.
About an hour
Paul
ago,
J. Fishman.
A federal jury sitting in the courthouse behind me found Bridget Kelly and Bill Baroni guilty of all counts in that indictment. We are gratified that the jury saw the evidence the same way that we did. I am unbelievably grateful to the jury for the hard work that it put in during that 6 weeks of this trial and during the 3.5 or 4 days of their deliberations. And I am enormously proud of the people in my office, the FBI, and the Office of the Inspector General, who worked so hard on the investigation and the prosecution of this case. I will take your questions.
So everyone is asking why you did not prosecute the governor. All the evidence presented in the trial pointed to the governor. He was in on these conversations, the same conversations. This jury convicted the two of them. Why did you not pursue the governor?
Well, I'm not going to answer the question why I did or didn't pursue anybody in particular. What I will say is exactly what I said at the news conference that we had when the indictment was returned in May of 2015, which is at the time we indicted only the people who we believed we had evidence beyond a reasonable doubt, which, as you know, is the constitutional standard, evidence beyond a reasonable doubt to convict in this courthouse.
Were you not able to take a new look at those texts?
I'm sorry?
Were you not able to access his emails or texts? What is it that, I mean, you had all this evidence that connected him.
Well, look, the public, and particularly those of you who are in the media who sat through the trial, and of course everybody who wants to read the trial transcript, obviously can reach whatever conclusions they want about the strength of the evidence and about whether the evidence of anyone else's involvement was in the hands of the government or came from the defense during its case. But I stand by what I said then, that in May of 2015, the evidence that we had that proved people guilty beyond a reasonable doubt was sufficient to indict and convict Bridget Kelly and Bill Baroni, and that's the indictment we asked the grand jury to return.
Now you have three witnesses who are saying that Governor Christie knew about it, approved it in advance, and talked about it while it was happening, including your witness. Why won't you bring a case based on all that testimony and the emails which we have seen and read?
Well, I'm not going to say, as you know, Andrea, I never say what cases I am or are not going to bring. But I will say, I'll respond to something you just said, which is three witnesses said it. Two of them were the defendants themselves. The defendants, that testimony is not admissible in another criminal trial against someone else unless those witnesses testify against someone else. It's not the way the system works. And without commenting about whether it would be sufficient or wouldn't be sufficient, the testimony of a witness in this courthouse against a person or about a person who is not represented in this courtroom is not actually admissible against that person in a subsequent proceeding, in all likelihood.
What will you do now that you have two more defendants?
I never comment on whether matters are open or closed, as you know.
What about the questions about the judge's instruction to the jury, particularly about punishment and pulling back from the indictment?
Well, so we didn't. It wasn't pulled out of the indictment. In the indictment, quite clearly described that the punishment of Mayor Sokolich was a motive for the defendants to have engaged in the conduct with which they are charged and of which they've now been convicted. Motive is always relevant in a criminal case, but it is not an element of the actual crime. The crime, as it was explained to the jury by the judge in her instructions, which were very carefully discussed by the parties with the judge before they were given, accurately described that the crimes with which they were charged was a crime to misuse the resources of the Port Authority for an improper purpose. The question of punishment is a question of motive. It was argued that way before the trial. The defendants made a motion before trial to keep it out. The judge ruled against them. They argued it again in terms of the instructions. At my count, this issue was argued at least 4 times before Judge Wigginton, who made a very careful and thoughtful decision about how to instruct the jury, and we believe that instruction was entirely correct.
How much prison time, Mr. Fishman, how much prison time do you think that they should get? What would the U.S. Attorney's Office recommend?
I don't yet know what prison time we will recommend. Obviously, the statutory maximum is quite high, but if you look at David Wildstein's plea agreement, for example, his guideline range for this case, specified by the United States Sentencing Guidelines, is about 20 to 27 months. The guidelines for the defendants will likely be a little higher than that because he was given credit for acceptance of responsibility in the way those guidelines are calculated. Our position, obviously, is that the defendants did not accept responsibility for their actions. And in fact testified falsely before the jury. So we'll have to see exactly what recommendation we will make.
For your sentences, could you consider a lower sentence if they were to come to you and say, I will testify in another case?
I'm not going to speculate about what we would or wouldn't do. It's going to happen for Mr. Wildstein, as you know. We will be bringing Mr. Wildstein's cooperation to the attention of Judge Wigginton, although, of course, she sat through the trial, so she saw his testimony, and we expect that the judge will give him credit when it's time for sentencing for having cooperated with the United States. Yes.
It's not the guilty verdict that obviously you were looking for, but with so much misdeeds in the governor's office exposed and so many people not held accountable for those, do you feel you've obtained true justice today?
Well, I'm not sure how you, Alex, how you would characterize true justice. We believe that the evidence in this case more than adequately proved beyond a reasonable doubt that these two defendants were guilty of the crimes with which they were charged. And that, for us, is a just result.
Do you think the cases you can bring have been brought?
I'm sorry?
Was she mastermind?
I'm sorry?
Was she mastermind? Dupe? What?
I don't think we described her as the mastermind. I think we described in our closing arguments David Wildstein as the architect of the scheme, but our arguments to the jury and the evidence showed beyond a reasonable doubt was that she was a very willing participant in the scheme that was charged.
Do you think the cases you can bring have now been brought?
I'm never going to answer that question to your satisfaction, I am sure. Our position is that all the legal issues that were litigated, that I anticipate that they will raise on appeal, were fully and fairly litigated in front of Judge Wigginton. I thought that the judge gave very thoughtful consideration to those issues from the time the indictment was returned 18 months ago and through the end of the trial today. And I expect that we will be in a very good position to defend these convictions on appeal.
What would you say is the overarching message?
How the defendants conspired to misuse Port Authority resources as opposed to making an agreement to punish Mayor Sockler?
Well, the agreement was to, as charged, the agreement was to use the resources of the Port Authority, the personnel, the lanes themselves, the toll booths, to achieve a purpose that was not a legitimate Port Authority purpose. We're not saying it's unrelated to the punishment. The punishment was the motive for what they did.
The punishment was not part of the agreement?
No, the punishment was the motive.
You've been listening to Attorney Paul J. Fishman, who was obviously instrumental in this case for the prosecution. We'll have much more as the day goes on. Of course, sentencing is now the next big day on the calendar, February 21st of 2017. We'll, of course, have a complete wrap-up coming up at 5 and 6 o'clock tonight.